On September 17th, 2010, I was traveling east on Central Avenue, turned right onto O Street, saw a DUI/license checkpoint ahead, approximately 300 meters. The cones started within, I'd say, 150 to 200 feet. I did to the best of my knowledge, a legal U-turn prior to entering the cone pattern, and I think it was legal because there were not cars approaching from either direction within 200 feet. I then turned right back onto Central Avenue, headed east. The Lompoc Police Department followed me and pulled me over, and I pulled over in the Miamore parking lot. I told the officer I thought that he was not supposed to pull me over because if I did not want to go through one of their checkpoints, I did not have to. He responded, and I quote, "The CHP allows you to do that, but we're not that nice." His name was Officer Corey Cox. So he cited me for a 2818 code violation of crossing a cone pattern or cone violation, and I also did not have my correct proof of insurance. I did have current insurance at the time, but I didn't have the documentation to prove it. So he cited me for those two things. I sent via certified mail and got a signature in response verifying that they received it, a notice that I was requesting a verified complaint. The court responded citing California Vehicle Code section 40513A and only the first part of A. Whenever written notice to appear has been prepared, delivered, and filed with the court, an exact and legible duplicate copy of the notice when filed with the magistrate in lieu of a verified complaint shall constitute a complaint to which the defendant may plead guilty or nolo contendere, followed by their notes. The defendant's signed written notice advising him of pending charges is the complaint. Failure to appear on the promise to appear or on the dates of the requested extension may constitute a separate criminal offense. Also on the sheet, it said the title is Plea and Notice of Court Trial, California Vehicle Code 40519. I hereby enter a plea of not guilty to violations, and it's blank. The bail is blank. I waive my right to be trying. So basically, a waiving time, place for my address, my signature, and then follow that. It says, your not guilty plea has been entered into the courts. The bail has been posted in the amount of blank. Failure to appear, forfeiture of cash bail posted, and issuance of a warrant for your arrest. The officer was supposed to show up, and the trial date is December 16th, 2010. So rather than going on November 17th, 2010, I filed with a notarized affidavit. I filed with the clerk removal of court-entered plea, Penal Code 1018, and also with a notarized affidavit, a notice and motion to dismiss, failure to state a cause of action, demand for a probable cause hearing. And I submitted this, and then the following morning showed up to court for my initial hearing on November 18th. 2010, and you can listen to the rest of the audio.
Good morning, sir.
Good morning.
Okay, I have a citation from September 17th indicating a lack of proof of insurance and traversing the flare or cone pattern. You sent in a letter to the court, a motion it looked like, indicating that you were requesting a verified complaint filed with the clerk. The court sent back correspondence indicating that under Vehicle Code section 4513A, the written notice to appear, which was then submitted to the court, sufficed as the complaint in lieu of a verified complaint, and that constitutes a complaint to which you may plead guilty or nolo, or not guilty and set it for trial.
Correct.
And I have a copy of the citation that was signed. So, you have to file the motions. Go ahead.
Correct. First of all, in 405, California Vehicle Code 40513A, in the correspondence from the, I don't know if it's from you or from the clerk, citing Section A.
Right.
It didn't cite the entire section. It says, except that a defendant may, by an agreement in writing, subscribed by him or her and filed with the court, waive the filing of a verified complaint and elect that the prosecution may proceed upon written notice to appear. And I have not done that. And in Section B, it says, if you don't mind, I'll just skip ahead to the part. Okay. What says, notwithstanding subdivision A, whenever the written notice to appear has been prepared on a form approved by the Judicial Council, an exact and legible duplicate copy of the notice when filed with the magistrate shall constitute a complaint to which the defendant may enter a plea, and if the notice to appear is verified, upon which a warrant may be issued. If the notice to appear is not verified, the defendant may, at the time of arraignment, request that the verified complaint be filed. And so I am requesting now, at time of arraignment, that the verified complaint be filed with the court. And I submitted it in writing ahead of time so you'd have a chance to review it.
And I appreciate that. I have had an opportunity to review it. I still believe that the Section A allows for the ticket to suffice. However, if you would prefer for the district attorney to file the same charges on an infraction complaint, I can order the district attorney to review the case and to make such a decision as to filing and bring this back in 2 weeks for us to then take the next step, which would be arraignment on that complaint.
It would be impossible for me to be here in 2 weeks' time.
Okay, what date would work for you? We only come back on Thursdays.
But before we do that, what about the removal of the court-entered plea?
Well, I set that for a trial so that you would have not necessarily a court-entered plea. It just appeared from your correspondence to the court that you were objecting to the charges in and of themselves, separate and apart from a verified complaint or not. So I didn't want to preclude your right to have a trial. It seemed to me that we would be able to address these issues at a court trial at the beginning of the trial, and then if it got to the point of actually presenting evidence for the trial itself, that would all be kind of a one date. So
you kind of lost me there.
Well, it appeared to me as if you were indicating that you were not guilty without really entering a not guilty plea. So I didn't want to preclude your right to a trial. So that's why I set the trial.
I see.
But I'm happy to set aside the idea that a not guilty plea was entered. That's not the court standing right now. What we're at right now is asking the district attorney to file a complaint, which is what you're requesting.
A verified complaint signed by him.
By him who?
Or her, the DA.
The district attorney.
Correct.
Right. When they file a complaint, it's always with the signature of the district attorney on it.
Okay.
So what date can you come back?
Well,
Arraignment on that complaint.
But then also, wouldn't there be a damaged party?
No.
No. Okay.
The code allows for citations to be issued alleging violations of the vehicle code. Right now, it alleges a vehicle code violation that you had no proof of insurance under 16028A of the code, of the vehicle code, and 2818 of the vehicle code crossing over a cone pattern. Those are the allegations. There's no aggrieved party as you would find in a civil lawsuit or something along those lines. So what date would you like to come back for your arraignment?
I still haven't, you haven't responded to the motion I filed, the notice of motion to dismiss, failure to state cause and action, and then if you do not dismiss, the demand for a probable cause hearing.
Right, the motion to dismiss is denied. You need to be, you're indicating that you want to be arraigned on your verified complaint. Yes, in your statement here.
Which statement are you looking at?
The notice and motion to dismiss. In order to have a verified complaint that you're requesting, because you're disputing the court's indication that the ticket in and of itself can be used in lieu of a verified complaint.
Correct.
In order to facilitate an arraignment on this matter, although I am in disagreement with your status of the law, I will ask the district attorney to file a complaint alleging the charges as indicated. That takes us to an arraignment stage.
Okay.
I believe at the arraignment stage, then, if you want to set a trial or a probable cause hearing, which technically I don't believe you're entitled to because it's an infraction, we can address that at that time.
That sounds good. December 16th, I believe, was the date that you had originally set?
Yes.
Is that a Thursday?
Yes.
I have your form here. And what time?
For arraignment, it would be at 8:30.
December 16th at 8:30.
Actually, I think it's on the 9 o'clock.
9 o'clock. Okay. And then in the meantime, okay, no, that's fine.
Okay. And what I will do is I will make a request on the record for the district attorney to take the packet of information, including all of your motions, and the citation, to review that, and if they so choose, then to file the verified complaint, which I believe that they will based on the citation in and of itself. We will have that for your review here at arraignment on the 16th of December.
Okay.
Okay?
Thank you.
Thank you.